Great. Good afternoon, everyone. I'm going to call this hearing to order and we'll begin with a Pledge of Allegiance. Pledge allegiance to the flag, United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Today's date is July 29th, 2026, and the time is 4:01 p.m. My name is Josh Soper, and I'm a hearings officer for Crook County, appointed by the Board of County Commissioners. I have a script that I'm going to read here, but before I dive into that, I just want to ask anybody who's planning on speaking to please fill out the forms and turn those in as soon as possible so that I can evaluate whether there's a need for a time limit on speakers. Okay, so I would like to start by talking about the process. This hearing is being conducted in person as well as by phone and Zoom. This allows members of the public to participate in person or remotely. For members of the public, if you would like to provide written testimony today, please fill out a testimony slip found at the entrance of the room and hand it to staff. When we come to the testimony portion, I will call those who want to testify from the slips provided by staff. Please wait until you are recognized by myself or staff to offer testimony. For those online, if you would like to testify, please submit a request in the chat function with your name and address, then wait to be recognized. I'd like to thank everyone for their understanding and patience. Minutes and audio recordings will be available on the public portal through the county website. This afternoon, I will consider the following: record number 217-26-0000166-PLNG, consideration of initiating revocation/modification proceedings of conditional use for aggregate mining. Record numbers 217-15-000115-PLNG, conditional use, and 217-18-000347-PLNG, modification of conditional use, located at 4755 Northwest Stahansik?
There you go. Yeah.
Stahansik? Got it. Should have asked that one in advance. Stahansik Lane, and identified by the tax lot numbers 1415140000702 and 1415140000703. Record number 217-21-000573-PLNG, Planning Commission Decision Conditional Use, and 217-22-000540-PLNG, County Court Final Decision Conditional Use, located at 6487 Northwest Lamonta Road and identified by the tax lot number 1415140000103. I think we're through the hard part of the hearing after reading all those numbers. The hearing is subject to the following criteria: Crook County Code Title 18, Chapter 18.172.070, 18.144070, and 18.172.100. I'll now move on to ex parte contacts, conflicts of interest, and bias. I do not have any conflict of interest or bias to disclose, and I have not had any ex parte contacts with the parties or any members of the public regarding this matter. Are there any members of the public in person or participating remotely who wish to challenge my statements? If participating online, please enter in a request to speak using the chat feature. Hearing none, I will move on. Before opening this proceeding up for testimony, either in person or for those participating remotely, I want to remind everyone that all testimony must be directed to the applicable criteria and standards. No person may testify without first receiving recognition from the hearing authority and stating their full name and address. No person may present irrelevant, immaterial, or unduly repetitious testimony or evidence. Please do not repeat testimony. Failure to raise an issue accompanied by statements or evidence with enough detail to give the hearing authority and the parties an opportunity to respond to the issues precludes appeal to the Land Use Board of Appeals on that issue. Failure to raise constitutional or other issues relating to proposed conditions of approval with detailed specificity to allow the hearing authority to respond to the issue precludes the party from seeking action for damages in circuit court. At the conclusion of the hearing, pursuant to Crook County Code 18.172.010, 081, the hearing authority may consider any request to continue the hearing or to leave the written record open. I also want to add, just to manage expectations, is that I will not be making a decision this afternoon during this course of this meeting. I'll be listening to everything that you all have to say, reading everything that was submitted. Some things were submitted just this afternoon, considering all of that, and then rendering a decision in writing within a few weeks. We'll start the hearing with a staff presentation. After that, testimony from any federal, state, or local agencies will be allowed. We will then offer an opportunity for the proponents to speak, followed by anyone neutral. Then the permittee may testify, concluding with final proponent testimony and staff. And just to clarify, when I say proponent, that is anybody who is advocating for the initiation of the revocation or modification proceedings. We will now proceed with staff's presentation.
Thank you. Here's Officer Soper. For the record, John Eisler, Crook County Community Development Director. I'm going to try to keep my presentation here in line with the air conditioner. This is probably not the most entertaining part. Can you pull up the PowerPoint, please, Katie? So just be a quick kind of presentation overview of today's hearing. You got to accept her. There we go. All right. Yeah, so this is record number 217-26000166 PLNG, consideration of initiation of a modification or revocation. Next slide, please. The permits at issue are termed the Woodward CUP, record number 217-1500001 PLNG, and the CUP, record number 217-220000540-PLNG. The scope of today's hearing is governed by Board of Commissioners Order 2026-18, which is limited to determining if the evidence presented today establishes a reasonable suspicion to initiate a modification and/or revocation proceeding. This is not a final hearing on the ultimate outcome or the ultimate facts at issue. Jeez. Too late. It's okay. I'll work with it. It's okay. Can you guys hear me okay? Okay. So the legal standard and the scope of this is, like I said, is the reasonable suspicion standard. This was borrowed out of a LUBA case, Imami versus Lake Oswego, where they kind of produced an ad hoc procedure for a revocation consideration. The threshold definition for reasonable suspicion that we are applying is a belief that is reasonable under a totality of the circumstances, or simply, is there any reason to believe? As I said in my staff report, this is borrowed from criminal law. The boundaries of this, so this decision serves strictly as an administrative gatekeeper on whether or not to proceed with a formal hearing. The hearings officer will not make factual or legal findings regarding permit revocation or modification today. This just addresses the threshold, jurisdictional, and evidentiary questions. Next slide. And so the provisions that govern that in our Crook County Code, we have a general modification revocation section in Crook County Code 18-172-100. There are, I believe, 4 separate criteria that can be applicable here. The only ones I think that the parties have argued would be at 100 sub 1 sub A, which is misrepresentation, concealment, or wrong information supplied in the application or application materials. And then sub D, which is the permit is being or recently has been exercised contrary to the terms or conditions of such approval. This addresses both modification and revocation of a conditional use permit. The next section is in chapter 18-144, which is our aggregate resources section. And there in 0.070 sub 3, there are 2 options. At sub A, it reads similar to sub A of 100, where it's false or misleading material or information supplied on the application. Or at sub B, intentional operations in violation of laws and regulations resulting in substantial injury. That addresses only revocation of an aggregate conditional use permit. So some real quick site history with the Woodward CUP that was approved in 2015. The approval is over a split zoned piece. I think it's two properties. And so one of those is EFU2. It's tax lot 703, 76 acres. The other is tax lot 702, which is zoned heavy industrial. There were 31 separate explicit conditions of approval in the Woodward CUP. On the Veneer CUP, which was approved in July of 2022, that is only one EFU2 parcel, which is 78 acres. Currently, that property has been unmined. There are two conditions precedent to operations starting there. First is through the county's conditional use permit. There is a requirement for an executed groundwater guarantee. That has not been executed yet, so operations cannot begin. They are also waiting for approval from Dogami through their operating permit, which covered Woodward, that was deemed a modification of that permit from Dogami to expand onto the Veneer site, and that has been held up through the groundwater sample analysis plan that is currently ongoing. There are references in the Veneer CUP for the Woodward CUP. For instance, the conditions of approval for Woodward have been carried over to Veneer. Additionally, the plan on the Veneer CUP is to use the Woodward site as a haul road to get to the processing facility. And so if something happens with Woodward, it may involve changing something on Veneer. Next slide. Here's just some quick background on the code compliance framework in Crook County. So we have a general complaints chapter 1.12. The overarching theme there is a goal of voluntary compliance, as that is deemed the most efficient way and most cost-effective way to resolve issues in the county. There's some stuff done in the staff report that I'm sure the parties will bring up, but there are, like I said, the overarching theme is voluntary compliance. There's some language in there about that voluntary compliance being abused if there is an extended period of time for a violator to come into compliance, or repeated violations, repeated violation, I think, of the same act. We also have a nuisances section for resource use. That's in chapter 18.148, which protects goals 3, 4, and 5 activity, any resource use, particularly against nuisance complaints. And then we have our aggregate violation section in 18.144. This section was brought into our code pursuant to a DLCD enforcement order in the 90s and is a section specifically written for aggregate operations. And within that at 18.144.070 is the enforcement mechanism for aggregate. Next slide, please. All right, so a broad summary of the evidence submitted by the parties. We've had one neighbor, the Mikulskis, submitted evidence and argument. We had one from Central Oregon Land Watch, and then we had a response by the permittee, and then there have been 2 new submissions today, one from Central Oregon Land Watch and one from Knife River. But broadly, what you'll read in the staff report is there have been 2 confirmed director's violations, one in November 2025 for operating a water pump outside of approved operating hours, and one in May of 2026 of this year for lack of vehicle barriers and gates. There was an enforcement action by DEQ in 2022 for acts that occurred in 2020 regarding dewatering and wash water discharge into the ryegrass irrigation canal. There have been state agency findings through correspondence between the county and Dogami regarding both the interpretation of the function of the settling ponds being an integral part of processing, and additionally statements regarding agriculture, regarding reclamation to agriculture and how that is incomplete on tax lot 702. There's also ongoing groundwater testing. Like I said, both DEQ is doing their neighbor sampling plan. They've done 2 runs of testing, and there is ongoing a groundwater sample analysis plan going on with Knife River that I believe should take, they can speak to this, but I think about a little less than a year till they think they might conclude. Next slide, please. And so I just want to address a couple things that were brought up between the parties. The first is the relevance of Johnson versus Land Watch Lane County. I just want to distinguish that and let the hearings officer know. So that involved was a lot of record approval, and apparently the deeds that were submitted that were used for that approval were forged. That wasn't discovered until 10 years later. And the Court of Appeals there, leaning on the need for finality with land use decisions, said that a county can't go back and unwind a decision at least past the period of statute of repose. But there are some distinctions there. They did carve out that that ruling would not apply to ongoing compliance with conditions of approval. And they did not address issues that may have been harder to uncover versus just looking at the county's deed records. One of the arguments was that 18144 is controlling, since these are aggregate operations, and my staff report I just pointed out that 18144 is silent on modifications, and only 18172-100 addresses modifications. There were also constitutional arguments raised in my staff report. I deemed those premature, as this hearing itself is only whether or not to initiate such a proceeding. And so the ruling today would not infringe on any constitutional rights. Next slide, please. Later in my staff report, I brought up some additional considerations outside of the parties' arguments. These involved statements made at the time of the initial approval of the Woodward CUP in 2015. The first were statements from Tim Marshall that where the processing area is, there's a site map in my staff report. The settling ponds are on kind of the west portion of the property of the EFU tax lot. And the statements were made during the hearing and through the submissions for that approval that the shallow aquifer did not extend to that portion of the property, and so there was no risk to groundwater with the location of the settling ponds. The statements, especially from the property owner Woodward, was that the mining would be strictly transient in nature and would be quickly reclaimed as operations moved across the site. And that it's kind of a repeat here that reclamation would be concurrent as cells are completed. And those statements have proven to not be accurate here 10 years later. And then I did reference a statutory authority in 215-299 2B that local governments and state agencies are to balance resource uses and only restrict mining where public health and safety concerns necessitate. Next slide. So in staff report, I summed things up as the request for the hearings officer today, or through your findings, your final decision is that you can either initiate a revocation proceeding under the county code, a modification proceeding, or decline to initiate further proceedings. And those are the options on the table pursuant to the Board of Commissioners order for today's hearing. That's what staff has. Do you have any questions?
Thank you. No questions at this time. We will now hear from any agency representatives. Are there any representatives from any state, federal, or local agencies participating in person or remotely who would like to offer testimony? Hearing none, I will now consider setting time limits on oral testimony. I have 3 sign-up sheets at this point. Has anybody else submitted a sign-up sheet, or does anyone else want to? Has anybody submitted any requests to speak online? Okay, with just the 3, I'm not too concerned about time. I want everybody to feel like they have an opportunity to say as much as they want to say, but I also don't want to have anybody talk for an hour. So I'm going to set a time limit of 20 minutes for each of the 3. If you feel like you need more time than that, let me know. But do not feel like obligated to use all 20 minutes if you don't need to. I will also be reviewing all of your written testimony.
So can we ask for more time if we get like to the middle of our presentation and then say, can I have a little bit more time, or we need to ask ahead of time?
If you are getting close to your 20 minutes, I'll ask staff to let you know that you're getting close to your 20 minutes. And if you feel like you need a little bit more time, just let me know. We'll use 20 minutes as a soft target for your presentations. How about that? Okay. So I will now call proponents to testify, starting with Adam Mikulski. And I have your address on the sign-up sheet, so I don't need you to state that orally. Before you begin your testimony, I do want to just note a couple questions that I have after reviewing the material so far. I don't feel obligated to answer these questions, but I just want to put these out there for anybody who might want to address them during their testimony. One is regarding section 18.144.070 of the Crook County Code. It makes a reference to violation of county laws or regulations. And one question that I didn't see addressed in any of the materials is whether proponents or the permittee believe county laws or regulations would include conditions of approval of a permit. And then the second question I have is regarding, this is probably more for the permittee, is regarding the statements from Dogami regarding the settlement ponds and the reclamation that Dogami says are violations, whether the permittee is aware of those allegations of violations and whether those current statuses are continuing today. With that, those are my two kind of guiding questions, but I'm interested in anything that you have to say, and I'll turn it over to you.
Yeah, it's a little different that I'm an opponent instead of or a proponent instead of an opponent. But do you answer that first question that you had on it? I think in some of the material that I actually sent in, I did reference the county code and the CUP violation and what the county code said. So I did reference those into there. Now, I don't know exactly the one you said, the number, because I can't remember it, but I did reference a lot of that in my testimony that I had sent in. And apparently you read it if you didn't see that. Okay. Does that answer the question?
I think that's sufficient for now.
Okay. All right. So just a little background. Adam Mikulski and my wife, Karen Mikulski, we live at 3992 Stancic Lane, and we live right across the street from the mine. And we had worked with, we've been here from the beginning in 2015 when all the hearings came over and all that. So to be honest, and probably in some of this in here, I'm going to state that we did work with Knife River to those CUP that they wrote it. And we were there with them, with their geologist and their vice president. And this is the stuff that we agreed to that would maybe help mitigate what's happening across the street. They presented that to the county and the planning commission, and that was accepted. So we've been involved from the beginning with this and have been involved every year through this whole process, including veneers and all that. So that's just kind of our background in there. So I don't know what I can say and what I can't, but I'll probably say it. And you say, well, you probably can't say that, but that's too late because I've already said it. Anyway, one of the things I wrote down is that ignorance of the law is no excuse. Ignorance of the CUP is no excuse. And I think with all the testimony that we presented and all that, it's just like when you live across the street, you see these things going, you do these violation forms and everything else. The people that work for them don't understand what the CEP said because they just don't follow it. And it's not that we just have one violation in 10 years or 11 years. It's like it's constant. And I'll reference some of that later on in what I need to talk about. So another comment I have is inaction by the county does not constitute a non-violation of the CUP. And I'm going to reference to an attachment dated 2/14/25. Woodward Knife River Quarry update, and this was sent back from Lewis Seals, the compliance officer. So those are some of the things that we actually put in as compliance issues. And berm tree management. So I'm going to give this to you later, but you can read it. But, meeting on-site identified 8 trees needed replacement. They will be replaced in no later than April 30th, 2025. Sediment placement received Knife River response with summarizes the on-site overburden was used to fill the cell 6 feet above the groundwater surface level. I'll address that later also. Weed control received response from Knife River, which summarizes the steps they have been taken most recently regarding weed control and continued maintenance. The CUP stated that it actually they were supposed to do a weed control plan from the beginning. I think they had one maybe for stipulation of, getting their permit and all that, but they didn't do it until we actually brought it up with a compliance violation. And then all of a sudden, so what did the county do? Is that a violation? It's not apparently because they didn't do anything with it. Dewatering, received response from Knife River, which summarizes that the last dewatering on site was 2020, which was reported DEQ. Nothing happened there either. Parking control, received response from Knife River, which detailed that the trucks were waiting for instructions from dispatch. You accept that as an answer when the CUP actually, or one of the codes says you park off street, off on the site itself. Vector control received Knife River response, which included the mosquito control plan for 2016. I don't think they've done anything ever since then until we brought it back up again. So that's where I think there's some inaction out there from the county, and it'll be in record. Okay, the CUP in an application to the county of similar requirements that Knife River has at numerous times not followed. The CUP was written and presented to the Planning Commission. The Planning Commission accepted the CUP as written. This was to mitigate any issues that arose with mining operations at the site. So the question would be, why has Knife River since 2015 chosen to violate the CUP requirement that they wrote and presented to the Planning Commission for acceptance? And then they talk about Goal 5. Goal 5 states that nuisances cannot deter the permitting of the aggregate mine. We went through this with veneer site. I don't think it does not, however, address that a CUP cannot be developed to mitigate nuisances that arise from aggregate mining. I wouldn't say this is a Goal 5 hearing. It's more of a CUP hearing and maybe their application. So I referenced this to attachment 5, which was presented by their counsel. It states on there that we are not aware of any allegations anyway, yeah, right. We are not aware of any allegation, much less any substantial allegation that Knife River provided false or misleading information in support of the application for the CUP. So I have attached various pages of the application to the county. I highlighted, I'm going to present it to them. I didn't get a chance to get it done before the hearing, but you can go through that, and I've outlined everything that they said they were going to do, the responses, and they haven't done it. Reference to attachment 5 again would be page 3, states the pump operation violation was in November of 2025, 20 months ago, and has not occurred again. Well, rather than them telling me about the Constitution and the violation of the Constitution, they should be taking a math class, because November of 2025 to May of 26 is definitely not 20 months. It's only 8 months, so it's recent. Reference to attachment 5 again, page 4 states allegations, violations, and serial complaints may not be used to determine proportionality or whether the permit should be revoked. They weren't alleged violations, they were violations. They were direct violations of the CUP and permit application when you read them. So then reference staff report that staff presented, the last staff report. Page 1 says relevant grounds for fraud, concealment, or misrepresentation, or on the basis of wrong information supplied on the application or given at a public hearing, which material relates to the reasons on which the permit was granted. Attached are various pages from the application stating the misrepresentations, and that'll go into record. Page 4, B, CUP compliance history. Permittee operated at the Woodward site from the receipt of its CUP in 2015 until at least 2022 without the county receiving formal complaints from neighboring landowners. The reason there were no formal complaints is because the county failed to let the public know that a form was required to be filled out to make a formal complaint. There were numerous violation complaints provided to the county between 2015 and 2022. And never once were we told that a form was required to make it formal. The only way we found out about it was at the commissioner hearing for the veneer, and then that was brought up in 2022. So that's why you have so many in 2022, because nobody knew they weren't going to take it as a formal complaint. So we were involved with Knife River in the drafting of the CUP, and they asked us to go directly to them if there were any issues. We did go to them. The issues were never got resolved. And the county was not aware of any violations, and that's what they brought up at the veneer hearings for the Planning Commission is like, well, we didn't have any complaints. Well, I think the county was pretty well lax on it, and we did what we did with Knife River, but apparently they don't remember any of that because they didn't state that they took care of that, because we also had the dust, numerous things. So, okay, so page 6 and 7 of the Dogami response to question 1. Based on Dogami's statutory definition of processing and the use of the ponds for disposal of processed water under DEQ 1000 general permit, The settling ponds are an integral part of the facility processing operations. However, it is not clear in the application materials that the pond was going to be used for processed water settling as part of the processing operations. So Dogami Operating Permit 9 states the permittee must conduct all processing within the tax lot 702, which the ponds are not. Based on the above considerations, the current use of the settling ponds on tax lot 703 is inconsistent with both the state and county approvals. I would say that was a misrepresentation by Knife River on the application and the CUP, and it is in the application on their response. Page 7, Dogami response to question 2. Says, please note the Dogami statutes and administrative rules do not provide a formal definition of the term mine ponds. This relates to the controversy over what is considered a mining pond for the violation of CUP 26. And 26 states all mining ponds will be backfilled with material sourced on the site, except that sediment from the settling ponds will not be placed within the water of any mining ponds. Sediment from the settling ponds was placed in water in the last mining cell that is open due to the ongoing water tests. Material was brought in from other mining site and processed at the Woodward site. It was washed and the fines traveled to the settling ponds. This offsite material was then applied to the open cells located next to the South Stehansik Lane berm. Also, Knife River brought in offsite material to be used as fill in the mining cells, and we don't know what's in there on those other ones. They talked about concrete, they talked about asphalt. We don't know. They won't dig it up. Dogami won't do anything about it, so I can't really tell you for sure, but that's just what I've heard from neighbors that saw it. Page 9, Dogami response to question 3, CUP condition of approval 22 and 23 state respectively. The site will be reclaimed concurrently with mining as cells are completed. That was not done. They stripped 35 acres and left it bare and then did their mining, and that's when they had to dewater. And we sent that in and talked to the county, and I don't know where that showed up or was disappeared. The site will be reclaimed concurrently as mining cells are completed. The word CUP, condition of approval number 22, appears to be clear, is that as soon as excavation is completed in a mine cell, the mine cell should be reclaimed back to agriculture. We sent in the pictures. If you've seen the pictures, what it used to look like and what it looks now was just weeds and brown, that hasn't been done. No portion of the Dogami permit or permit condition prohibits Crook County from enforcing the land use conditions of approval. This is currently a misrepresentation of the permit application in violation of the CUP. Attached, it's outlined. It'll be in record. Page 10, number 3, Water Pollution Control Facility 1000 General Permit states, permittee's noncompliance notice of December 7th, 2021 states that the permittee just found out that some of the water from the excavation activities was pumped into the canal when the water in the settling ponds reached within 1 foot of overflowing. They didn't just find out. The reason they found out is because my wife put in a complaint into, I believe it was Dogami, then went to DEQ, and then all of a sudden they all self-reported and stuff. They installed an underground line to be able to discharge stormwater, pond water, and excavation water into the Ryegrass Canal. You can't build an underground line as long as it was, and if you see that map in what I presented earlier, you can see for their fine, you can see where they were discharging the water and how far it had to go. You just found out, and then, you know, oh, we had to hurry and do it. It was planned, which means it was the best misrepresentation, or they're just lying about it. Reference the DEQ map showing the water traveling. Presumably, they tried to disguise the water line as a main line for irrigation, and it is there, and I think it traveled through that line, but it wasn't used for irrigation. It was just disguised as an irrigation underground line with risers coming up. So attached is a permit application, misrepresentations highlighted, all responses from the applicant, including Craig Woodward's Dogami application. They all show numerous misrepresentations and all responses tied to the CUP, because what they asked for in the application, what they said they were going to do on their responses, most of them were included in the CUP. And I can go through some of those really quick because I highlighted them, but it's a long one. But I still got 20 minutes, right?
I do have your written materials, just so
Okay.
you don't need to repeat them.
I got 5 more minutes. Okay. Do you have the from the county? Did you read actually their application?
I have all of that. I have a.
Okay. You have the book?
I have all this.
All right. Well, my book's not that big, sorry. But, you know, I can go through it, but it does deal with, I won't go, they talk about reclaiming, they talk about that they aren't going to de-water, they talk about cattle and grazing, they even talk about the weed control plan, they actually got it. Right there, the county actually sent them the material that's in there to say what weeds are noxious and what you need to control and how you need to do that. They agreed and they did the control plan all these years until it was asked that it would be done. It even tells you in there it's got to be done by December 15th of, you know, the year or something like that, the end of the year, every year. So really, how can you say it's not misrepresentation or they didn't do it deliberately or whatever? But I think if you're not training your people and the people that work there don't know what the CUP says, then let them go and do it. And then it violates what we to. And that's what I think we've been living there for 11 years with this, and over and over and over. The trees, you know, they said they were going to do the trees. That's a violation right there. They didn't take care of the trees. And then we meet with them and they use a word like nitpicky. And which was the wrong word to say, that it's nitpicky, because if you guys would follow the CUP, you would replace those trees and we're not being nitpicky. And it even tells you in there what size they got to be replaced with rather than one that's this tall when the rest of them may be 10 feet tall. So all that's in there and they choose not to do it. So I can't say why they don't want to do it, but they can, but it's all misrepresentation by all the stuff that I actually looked through, the permits and all that, and I've been involved in that. So I don't know if Karen's got anything to say. I think I'm going to make my 20 minutes. 2 minutes. Ooh, 2-minute warning. You have anything?
No, unless you want to go over this at all. Did you want to do anything with it?
Yeah, I can mention this while I've got 2 minutes. This is some notes that we had that we met with Knife River in the trailer on the 6/13 of 19. We talked about dying trees, replacing the trees. We talked about the weeds. We grass on the berms not taken care of. Next 5-acre call to sell to start. Our working Saturdays, Sandy's property, all this stuff. You know, this trees, weeds, dust, everything we talked about. It just continues, and then we have to write complaints to do that and stuff. So they're not choosing to do anything. So I would say that's they're doing it on purpose, or they don't care. Anyway, any questions for me?
I don't have any questions. Thank you for your testimony.
Well, I'll be open to questions if you have more afterwards. Thank you.
Next up, I have, I believe it's Rome Hayakawa from Central Oregon Land Watch.
Okay. A little loud.
This one's cutting in and out.
Okay, I see.
This stuff that now, you didn't tell me?
I didn't know until you were done. I have a backup.
Are you saying it loud?
No, I think that was me. Good afternoon, Hearings Officer Soper. It's good to meet you. My name is Robin Hayakawa. I'm an associate staff attorney for Central Oregon Land Watch. Our address is 2843 Northwest Lolo Drive, Suite 200, Bend, Oregon, 97703. I want to start by thanking you for hearing public testimony on this issue and your attention to the matter. I also, as ever, want to thank and recognize Crook County planning staff for all their hard work and preparation for this hearing today. And of course, the Crook County Planning Commission and the Board of Commissioners who heard the concerns of community members and decided to initiate this process. I've said this many times, but the present wildfires notwithstanding, I genuinely believe that the issue before you is the most important environmental, public health, and land use issue facing Central Oregon today. As for what's at stake here today, in some respects, I look at it as not very much. This is a preliminary land use hearing to determine whether further proceedings are justified under Crook County Code. The legal standard before you is reasonable suspicion, any reason to believe. In our view, that is a low burden, easily satisfied. In other aspects, though, Landwatch's hope is that this is a big first step for Cook County. And it's a big first step in protecting an agricultural and residential community that has had their lives upended and damaged by the mining operator who has proven to be unwilling or unable to keep the promises that were made 10 years ago when they first gained permission to begin their operation. Turning more to the merits now. I don't want to repeat everything that we've submitted in our written comments, including additional written comments this afternoon. I instead would like to mostly focus on what we see as sort of the central legal issues in front of you. And much of that pertains to the scope of Crook County's enforcement authority. So in Knife River's written comments submitted on July 15th and then again today, they asked you to adopt sort of a narrow interpretation of the code, and that would effectively eliminate the remedies under the general provision. John talked about this earlier. It's at CCC 18172-100. And under this interpretation, whenever a mining permit is involved, the county is basically limited to pursuing revocation only under the aggregate code at 18144-070. We disagree with this interpretation. We think it's wrong. We don't believe that it can be reconciled with the text and the structure of the code. I will start with the text of 18144-070, which no part of it states or even suggests that it is the exclusive mechanism for addressing violations involving mining permits. We believe that if it was the Board of Commissioners' intent to make such a limitation, they would have included some sort of language, any language that would have indicated that. And then I also want to direct the hearings officer to the plain language of the general provision at 18172-100, which states, quote, "The hearing authority may revoke or modify any permit granted under the provisions of this title on any one or more of the following grounds." It's really broad. It's really sweeping language. It's inclusive language. And our view is that it really cannot be ignored and should not be ignored. The code provides that any permit granted under the provisions of Title 18, this permit was clearly granted under the provisions of Title 18. A permit can be revoked by the county hearing authority based on establishing certain grounds. Knife River is welcome to challenge the effect of this provision. We expect they will. But the fact is that CCC 18172-100 is applicable to mining permits granted under Title 18, and it's difficult to argue otherwise. That relates in part to the second issue I want to raise today in oral testimony. Landwatch would like to respectfully urge you not to limit the county's available remedies at this early stage. The staff report does seem to emphasize that modification of the permit under the general provision 18172-100, not revocation, could ultimately prove appropriate and perhaps more right-sized based on the record. The language staff used in the staff report is, quote, "Staff believes it may be necessary to delineate separate thresholds to initiate a modification proceeding versus one for revocation." That may be true. We acknowledge that. Landwatch, I don't think we are unreasonable. But at this juncture, we don't believe that it is an appropriate determination for the hearings officer to be making. The ordinance 2026-018 asks the hearings officer to make a decision on the limited issue of whether there exists a reasonable suspicion to substantiate the initiation of a modification or revocation under a specific subsection or subsections of the Crook County Code. 18172-100 makes no delineation between a revocation or a modification. The standards are the exact same. So in that regards, we would view a determination by the hearings officer to limit to just modification, not revocation, as a legal finding, in that goes to sort of the ultimate issue, limiting the remedies. And so we don't think that's appropriate or allowable at this early stage. And finally, I'd like to stay out of the factual weeds for the most part, because I believe the record in front of you, which is now probably over 1,000 pages, very hardy, a lot of evidence. I think it's, I believe that it is enough to satisfy the sort of factual record that would justify a reasonable suspicion. So with that, I would like to sort of just zoom back out. The applicable legal standard here, pursuant to 2026-018, the ordinance is reasonable suspicion. As John noted, this is a standard borrowed from LUBA case law, Imami versus the city of Lake Oswego. It's interpreted this to mean, quote, any reason to believe. Again, the risk of being redundant, it's a low standard, easily satisfied. What we have here is a 10-year-old conditional use permit. At the time of issuance, community members raised many concerns, ranging from hours of operation, fugitive dust mitigation, traffic concerns, impacts on surrounding agriculture, impacts on agriculture on the subject property, and of course, the protection of groundwater in the area. To be clear, we're not alleging, we're making no specific allegation that Knife River is responsible for groundwater contamination. That said, community members in Crook County were promised by the county and Knife River that these concerns would be mitigated and that they would be protected from the impacts of the mining operation. Central to the promise was the terms and conditions of the CUP. Since that time, the record that's in the large binder that you have demonstrates that almost every single one of their concerns have come true. They have been completely vindicated in the worst way possible. The record demonstrates that Knife River has illegally dewatered the site. They've failed to concurrently reclaim the property to agriculture. They've failed to control fugitive dust on many occasions. And of course, the groundwater in the area has become dangerous to consume for both livestock and humans. I did this throughout our written comments. I'll do it here again. This is also supported by the language of Imami and the reasonable standard, which talks about totality of circumstances. But I urge you to look at the totality of the circumstances and apply the applicable standards here to determine that not only is there any reason to believe, but there are dozens of reasons to believe that Knife River has made material misrepresentations in the past, that they've conducted mining operations in violation of state and county regulations, and that they have continuously and recently been in violation of the terms and conditions of the CUP. In sum, to be clear, we believe that further proceedings under 18144-0703A and B and 18172-100-1A and D are all justified by the record in front of you. And we respectfully urge you to find the same. If you don't mind, I'd like to address one of the questions you asked. The question you asked is based on the language out of 18144-070, do regulations can include conditions of approval? Our perspective is that they do. You can see based on the text of that that ordinance that they say laws and regulations. We see regulations as something more expansive and more inclusive. I would also note that it appears that the conditions of approval are implementing specific regulations within the Crook County Code. So for instance, there is a series of conditions, I think it's 23 through 27 or something to that effect in the CUP, and it's titled groundwater protection. This aligns with other provisions of Crook County Code like 18144-060 sub 10. These are development standards, and sub 10 is surface and groundwater management. Surface and groundwater management is I would describe it as sort of like a vague aspirational protect the groundwater. And so in our perspective, the conditions of approval are either directly regulations or are implementing regulations and fall within that definition. As to your other question, I think that might be best answered by Knife River. Thank you so much.
Thank you for your testimony. Seeing no one signed up for neutral testimony, we will now move on to the permittees testimony. I have Mark Bartholomew signed up.
Good afternoon, Mr. Soper. I'm Mark Bartholomew, counsel for Knife River. My address is 14 North Central Avenue, Medford, Oregon, Suite 104, 97501. I first want to note that I submitted a couple letters in the record. I thank you in advance for reading those and all the other reading homework you are going to have. I'm going to state the obvious here. This is a very unusual hearing. I've been an attorney in private practice for 20 years, also been a city attorney to multiple jurisdictions. In Southern Oregon, I'm still city attorney of 2 or 3 cities. I've also spent considerable time representing developers, businesses, and including concrete and aggregate producers around the state of Oregon. And I have never seen any party face such an extraordinary potential remedy as Crook County has facilitated here today. That being said, I ask that this issue be framed in the proper lens. First off, Crook County Code 1.12.130 promulgates the county code's policy to encourage voluntary compliance and an opportunity to comply with state laws and county ordinances with little or no penalty. Clearly, that's not what we're talking about today. Or clearly, the hearing today is irreconcilable with that stated policy. Secondly, the Crook County Resource Protection Ordinance states that resource uses sometimes offend, annoy, interfere with, or otherwise affect others located on or near resource lands. Well, the drafters of the code were obviously clairvoyant because that is what's happened today. This is the type of operation envisioned by the Resource Protection Ordinance because it's a Goal 5 resource. I know from being on both sides of the aisle, neighbors just flat out don't like rock pits. And that's why we have a specific ordinance for aggregate resource revocation, which would be the operative criteria for revocation if it went to that. And that is CCC 1814400703. And that provides a couple of criteria for potential revocation. Of course, it is permissive. The first is if the applicant intentionally misled the county in its initial application materials to obtain approval. I don't think there's any evidence of that. Second criterion, it's an alternative to that, would be if the operator is intentionally conducting mining operations in violation of law, and that intentional violative operation results in substantial injury. There's been no allegation of that either. And the reason there's no evidence of that is because it's not doing that. There's a lot of allegations about wrongdoing, but the truth is Knife River has been found guilty of 2 different county violations. One, I believe, was running a water pump outside of hours, and another was having a portion of fence that was incomplete around a site. Those are minor violations. You're hearing a lot about allegations and unsubstantiated complaints. I think we all have enough common sense to know that when neighbors rally around something in the neighborhood they don't like, they're going to make lots and lots and lots of complaints. I think there's a good reason that a lot of those allegations were never adjudicated as violations is because they were not in fact violations. So I ask you to view all of this, all of these allegations with a grain of salt. I think doing otherwise would lack required due process. Rumors and innuendo are not how we operate in a nation of laws. Setting aside code language and laws, revocation, as I mentioned at the beginning of my discussion, is an extraordinary remedy. Common sense by anyone other than those who are impassioned about this would dictate that revocation would be inappropriate. You cannot take away a property right without, as we say in government, progressive discipline. None of that has occurred here. This is a potential for going 0 to 60, and it's overblown. I'd ask that you deny this request. Now, I think that you had a couple of questions at the beginning that you specifically asked for the parties to answer. And I think one of those questions is probably more properly answered by my colleague, Matt Robb. So if you want to come up, Matt.
Good evening, Mr. Hearings Officer. I did not complete a form. I assume I can still speak. Is that correct?
That's fine. Yes.
Okay. My name is Matt Ropp. I work for Knife River. My office is at 32260 Old Highway 34 in Tangent 97389. Could you please repeat the two questions that you had for permittee?
Sure. So I think the question that you've probably been asked to come up to discuss is kind of the factual one, which it may be somewhere in this 1,000+ pages, but I didn't see it. It certainly wasn't addressed that I saw in any of the letters that were submitted. And that is, there are a number of allegations and statements from Dogami about settling ponds and reclamation related violations. And the question that I had, I didn't see addressed there, is Knife River's awareness of those potential violations and the current status of those potential violations.
Starting with the settling ponds, I believe that this stemmed from a question posed by Crook County Planning Director John Eisler. And it was related to whether or not process water ponds are considered processing under the definition of mining in, I believe it's ORS 517 is the statutory chapter, ORS chapter that Dogami spoke to. I understand the question really was, are the process water ponds allowed in the EFU zone, whereas there's a condition in the county approval that requires that all processing activity be located in the industrial zone. I believe it was Von Balzer of Dogami spoke to what the Department of Geology considers to be processing, and did emphasize that process water ponds under the definition of ORS 517 would be considered processing. What Mr. Balzer's findings neglect is the extensive testimony in the record related to, and when I say the record, I mean the county record for the Goal 5 and CUP approval at the Woodward location. Testimony that speaks to the location of the process water ponds and how the process water ponds would be used. And so my view of Mr. Balzer's statements is that he answered the question asked, which was, are process ponds considered to be mining? But Mr. Eisler was asking effectively for an interpretation of the county land use record, and you need to look to the county land use record to get that answer. And I'm confident that the county land use record supports the fact that the decision makers in the Woodward Goal 5 and CUP cases clearly understood that the process water ponds would be located on the north side of the property in the EFU zone, and that they would be used to support the processing activities. Does that answer your question, sir?
Mostly, I think the the heart of my question is whether is not whether it actually constitutes a violation, because that's not the question before me in this proceeding. I'm just trying to make sure I understand the status of that issue. So, as I understand it, Dogami took the position that it may be a violation, and I want to understand whether that potential violation has been resolved from Dogami's perspective, and I guess the communications between Dogami and Knife River regarding this potential violation issue.
There's been no discussion with Dogami on whether Dogami believes that the processed water ponds located where they are and used in the way that they are a violation of a condition that is subject to Dogami's authority. Dogami's not pursued anything. As I understood the request from Mr. Eisler and Dogami's response, it really was a matter of the county inquiring whether Dogami felt the ponds would be considered processing. And Dogami did answer, yes, we would consider those processing. But I don't believe that Dogami sees the ponds as a violation of Dogami's rules. I believe they were trying to offer some insight into what Dogami considers to be included in processing. But again, to truly answer that question, you would have to review the whole record, and you would find that the Planning Commission and the court did consider the location of the ponds and how they would be used on the EFU zone. So I don't believe that that's a violation.
Thank you. I think that answers my question, which I'll put it one different way. What I see in the record is communications between the county and Dogami about this issue. And I was trying to establish whether there are communications between Dogami and Knife River about that issue as well.
I'm not aware of communications. I'm one of a number of Knife River employees that work with Dogami, but I don't recall a conversation about that particular matter.
Thank you.
Yes.
That answers my question.
That's the question. Okay.
It was on that and the reclamation issue.
Yeah, and specifically, what was your question on reclamation?
This same question. Basically, there's communications between the county and Dogami about a potential violation of Dogami's regulations related to an alleged failure to reclaim cells as they are being processed. And I'm curious about communications between Dogami and Knife River on that subject.
I'm not aware of any conversation or communications where Dogami has advised Knife River that they believe that we're out of compliance with the reclamation plan. I'd like to respond in writing to make sure that I have the opportunity to review both Mr. Eisler's letter and Mr. Balser's letter. I believe that there is a more recent letter in the record where the question is asked again. The question is specifically, is Dogami aware of any change to the site? And I believe Mr. Balzer responds that he's not aware of any change to the site, but I don't believe that speaks to Dogami's belief that there's a current violation. But I'll follow up on that for you, sir.
Thank you.
And what was the other? I believe, Mr. Hearings Officer, you had another question.
Yeah, the other is more of a legal interpretation question, so probably more for you, which is the one that Central Oregon Land Watch addressed as well, which is in construing 18.144.070 of the code, it makes a reference to violations of county laws or regulations as one of the types of violations that would have to be established as an intentional violation. And a lot of the allegations that have been made are regarding violations of conditions of approval. And so curious the parties' perspectives on
18.144.070,
Right.
which parentheses, which number?
sub B, 3B. Intentionally conducting mining operations in violation of federal, state, or county laws or regulations.
Okay. So, I want to be careful about how I answer that because you're asking it. And I think that that would merit some time for some briefing. And this is a good segue into our request, which is I think Matt Ropp indicated he wanted to respond about something in writing. I believe Mr. Geisler in his staff presentation just now introduced some kind of juxtaposition of 2015 and 2025 that we hadn't seen before. We consider that new evidence, and we'd like to respond to that. So I'm hoping we could get the record left open. We'd respond to that. Matt would respond to you, and I would get you some briefing on the matter of whether conditions of approval are laws within the context of that code provision.
Great. I received your request for a continuance to open record period. I'll discuss that in a few more minutes. But is there anything else that you want to present as part of your presentation at this point?
That concludes it.
Great. Thank you.
Thank you.
At that point, I will move on to proponent rebuttal. Do either of the proponents want to provide any rebuttal oral testimony at this time? And I will note that we have had a request for either a continuance to an open record period. And it's because this is the first evidentiary hearing, I will be granting that. So this isn't your last opportunity, but you do have an opportunity right now to make an oral rebuttal. I'll start with Mr. Mikulski. Do you want to? Sorry. I would ask that you keep this to about 5 minutes if you can.
It won't be long.
I guess they were talking about this is different, that nothing's ever happened like this before. I think the thing is here is that this thing should happen because of all the violations they have. You know, when it's an economic $500 to Knife River is like 5 cents or even less than that. Whatever they get fined, they make millions of dollars even across the street. But you know what? They don't take any of this thing serious because by all the evidence we presented, they just keep doing the same things over and over again. So for them, if they lost a lot of money, maybe they would turn around and say, you know, we're going to follow these things that we agreed to, that we presented, that we wrote out there, and you guys accepted it, and we're going to do that. And so if we move to the next place, we're going to do the same thing. That would actually show them that they need to do something, and that would show the other aggregate operators in the area the same thing, because they are going to move through this valley, I guarantee you, and they need to comply. I mean, yes, it is dust, it is, but the CUP is written to mitigate some of that. And there has been no mitigation because they don't do it. They don't follow it. And I think there was something that they were talking about, the mines and the ponds and everything. Going through all the evidence, even from the beginning, we will do it we're going to do it on the tax lot 702, I think is the one that's the commercial one. It's all there, and they said they would. And I don't care what they did later on or whoever did in the commission or whatever, because I've been to those commission meetings. I don't think they even understood what they were doing. But it states there from Dogami that they were supposed to do it on 702. They put it in their application on 702. I believe even Craig Woodward put it on 702. And then they didn't do it, and they didn't line it, they didn't do anything, and now they have these issues. And I don't care what Tim Marshall said, there's no water under there. Big deal. It's still in the EFU area. And some of the stuff that they talk about, water was at 10 feet when they did their test wells. So water's all over under there. Maybe not in that one spot, but directly across the street. It doesn't take them long to hit water because they had to put 3 monitoring wells because one of their backhoe operators, when they hit the ground, said there was like a river running under there. So they thought they were going to have a lot of water in there. So anyway, punitive damages, yeah, that's what they need because that's what needs them to straighten out and take this serious because they're not taking this serious. And we've had to live through it, the neighbors and ourselves. I think that was all. Was it 5 minutes? And okay.
Came in under the clock. Thank you
All
for
right.
testifying. Mr. Hayakawa.
Thank you, hearings officer Soper. I wasn't aware we would get a rebuttal period. Normally I'm on, I think Mr. Mikulski said this, normally I'm on the opponent side, not the proponent. So I'm not used to getting the last word, but it is welcome. I'd like to start by addressing some of Knife River's testimony. Knife River's representation, Mr. Bartholomew spoke repeatedly sort of about adjudicated violations and claimed that Knife River only has 2 adjudicated violations. Setting aside, Knife River has 4 adjudicated violations, to be clear. Furthermore, the standard that violations need to be adjudicated is not found anywhere in the code provisions that were cited to you. And so I believe that's an invented standard that at this point is not material, and that is something that can be adjudicated later on through a full and robust revocation or modification proceeding under either of the code provisions. The other thing that Knife River's representation said is that you should take the claims of neighbors with a grain of salt and sort of characterize them as like a mob of people that I just hate rock pits. I don't think this is true. There is a rock pit operating literally across the street from Knife River, known as the Williams Pit, that has been operating for someone who lives in the area could know this for certain, but I believe for decades without issue. It's not in the record before you, but my understanding is that there have been few, if any, complaints about the operations of the Williams Pit. So this is not a group of activists. It's not a group of people with an axe to grind. This is a group of people who have been damaged and disrupted by the Knife River's inability to mitigate the impacts that they promised they would. Finally, I want to talk about Dogami. You asked some questions, and the Dogami letter. I believe part of what you were getting at is if Knife River is aware or should be aware that Dogami has made these interpretations. I'm not. I can't speak to whether Knife River has seen the memo from October 31st, 2025. I would think that they have, considering that was about eight months ago now. But what I would say is that the record in front of you contains allegations of violations that are the same, i.e. the location of the settling ponds and the failure to concurrently reclaim the property in code complaint forms that were submitted by members of the public. So the idea that Knife River is completely unaware that they have these obligations is not demonstrated within the record in front of you. If you wouldn't mind, I'd like to take about 30 seconds and think if I have anything else to add. To the extent it's relevant, I did want to talk about something that was mentioned in the staff report and mentioned by Knife River as well, which is this idea that Crook County should seek voluntary compliance. I agree that is, I don't have the code provision in front of me. I agree that is in the code, but I would like to reference another code provision, and that's at CCC, these aren't my written comments, CCC 1.12.130 sub 1 CII. And that one is titled Limited Opportunities. And it says, voluntary compliance without penalty or cost recovery will not be allowed where the alleged violation is a repeat offense, either on the subject property or by the violator, or where the original violation was not corrected following the prior enforcement action. I would argue that, this code provision says repeat offense on the subject property by the violator or where the original violation was not corrected following the prior enforcement action. I would argue that we have all 3 of those here. We have a repeat offender who is committing the same violations repeatedly. We have a series of violations that are occurring on the same property over and over and over again. They may be different in their character, but it's the same property. And I would also argue that there's instances where the original violation was not corrected following prior enforcement action. And I think with that, Land Watch rests. Thank you so much for your time.
Thank you for your testimony. The staff have any other comments in response to the testimony or evidence offered?
Here's Officer Soper. Would you care to hear my opinion on whether or not a conditional approval is a law or regulation?
Absolutely.
I'm off the cuff. And so I don't know if I have time to brief this. I don't know if you want my opinion. I know as Community Development Director, it is my obligation to interpret our code. Typically, laws are of general application. They are passed via legislation. There are some weird quirks of land use law, as in we have a section in our code for quasi-judicial legislative amendments. That doesn't make any sense to me. But I see conditions of approval basically as contractual obligations between the government and the permittee. And so I don't see them as laws or regulations. Again, this is off the cuff. And I would, I guess, point to the language in 18144. In addition to any other 18144-070, in addition to any other remedy available by law, the county may establish a violation of this chapter, which would be a law, or of any condition imposed on a permit issued under this chapter in the following manner. And so, since they're listed in the disjunctive there, since a conditional use permit is a quasi-judicial decision, I don't see that as a law or regulation. As to Mr. Hayakawa's comment about our language in 1.12 on limited opportunities, it does state there voluntary compliance without penalty or cost recovery will not be allowed where the alleged violation is a repeat offense. I interpret that to mean it has to be the same offense that's happening over and over again. That's where the leniency is removed. As shown in the record, these violations were mostly they mostly changed. Some of these are there that have stayed, but there are ones where, like where the settling ponds are, where that's not really an easy remedy. And there was a response from the permittee on that, and that is why that issue was brought up to you today to try to resolve, because there is ambiguity, I think, in the conditional use permit as far as where those settling ponds can be allowed and what they are and what function they serve. And so it's a tough thing to untangle, and so that's why I'm bringing that to you today. But I think that's all I'll say for now, unless you have any questions.
No other questions at this time. Thank you. All right, now we have a request for a continuance or open record period. I'm going to do an open record period. Typically, that would be a 777, which would be 7 days for new evidence and testimony, 7 days for responsive evidence and testimony, and then 7 days for a final written rebuttal, which would be for the proponent's final written rebuttal. Just want to make sure that the three parties who testified all feel like that time frame would be workable for you before I establish that. Any concerns?
May I approach? I think that sounds fine. I just want to make sure I properly transcribe what may all happen in each one of those 7-day periods.
So 7 days from today, so by 5:00 p.m. on the August 5th, would be for new evidence and testimony to be submitted. And staff, I assume this would be submitted to the Community Development Department. Yeah. New evidence and testimony by the 12th of August.
And that would be for any party.
Any party. 12th of August, again, any party, responsive evidence and testimony based on what was submitted during that first 7-day period.
So yeah, they would be submitted to the email plan at Crook County or or.gov, and then by 4 p.m. That's our typical deadline for dates. 4 p.m.
4 p.m. 4 p.m. on the 12th for any responsive evidence or testimony. So any party responding to the evidence and testimony submitted during the first 7 days, And then the last 7-day period ending on the 19th of August would be for final written argument. That's testimony only, no new evidence. And that is for the proponents because they bear the burden of proof in this process.
I'm going to note an objection for the record to, as I mentioned, this is very unique. And the scheme that you laid out, identifying a proponent and whatnot, makes perfect sense in 99% of land use hearings. This is a land use hearing, but it's not a land use application. I don't think the folks you're referring to as the proponents filed an application for the development of land. I think the party with something to lose here, and depending on the outcome of this, is Knife River's entitlement. And so I think at a minimum, Knife River should be able to weigh in the final open record period with argument, not new evidence.
I'll note that objection. I will say I recognize that this is a very unusual proceeding. I'm using the term proponent intentionally rather than applicant because I also, my perspective is there is no applicant in this proceeding. There have been a few cases that have gone to LUBA under some similar circumstances where the term proponent has been used because the proponent of a particular outcome, a finding of compliance with particular criteria, has the burden of proof. And so because Knife River does not have the burden of proof here, if the burden of proof is not met, Knife River prevails here.
I understand. That's the other side of the coin.
Right.
The one side is my client's entitlement. The other side of the coin is the assignment of the burden of proof.
Right.
So I get why you're doing that, but I feel that I need to make this objection.
It's prudent to make the objection, and that is noted in the record. Thank you.
All right. Thank you.
Anyone else have any questions or concerns about the open record process? Yes.
I just wanted to clarify, Hearings Officer Soper. You said that the period until August 5th would be available for new evidence from the parties. And I'm wondering if you're using that word deliberately, so it'd be limited to Landwatch, Knife River, and Mr. Mikulski, or if this is I don't know what the right characterization is, but a true open record period where anyone could submit evidence, even if they didn't appear in front of you today.
That's a great question. Thank you. I'll accept new testimony and evidence from anyone during that time period.
Thank you.
Okay. Thank you, everybody. I really appreciate everybody who testified and everybody who came who didn't testify. There being no further business, the meeting is now adjourned